Well, we have constitutional sheriffs that are constitutional to the point that they're comfortable. I mean, that's the point with a lot of these constitutional officers. So if you have a constitutional officer and he says, I support and defend the Constitution of the United States against all enemies, both foreign and domestic. Okay, well, the Constitution includes this little thing called the Bill of Rights. It's a funny little thing because the Bill of Rights does not bind people, it binds government. Though that Bill of Rights contains the policy that predate the Constitution, literally. And there's a couple of Supreme Court cases that say that that's true. And we know it's true because we fought a revolution against the legitimate government of the day, the British government. We were Englishmen, we were British citizens in theory. And we fought a war against them because the king was beginning to violate God's laws against the basic liberties of man. English writers have talked about it, Roman writers have talked about it, Greek writers have talked about absolute rights, natural law, nature's law, nature and nature's God. All of those things predate the Constitution. So you talk about the Second Amendment, and you have to ask yourself, well, where did that come from? Was the Second Amendment an invention of the United States government after the Revolutionary War? Absolutely not. First of all, there's a case called Cruikshank versus United States that says that the Second Amendment is absolutely and utterly unconnected to the Constitution because it predates the Constitution. It is not dependent on the Constitution for its existence. That is a natural right that people enjoy, and how can I prove that? On April 19, 1775, 70 men were standing in Lexington Green with their own rifles, their own equipage, their possibles pouch that contained their own shot, their own powder. They had their own backpack with their own rations in it, and they owned those guns, and they picked up those guns from their hearth and from their home and over the door and over the fireplace, and they walked outside their home with those guns in plain sight and walked down to Lexington Green, and they all lined up, and at that point, only at that point, they began service in the militia. Because the obligation of the individual to own the weapon and own the accoutrements to the weapon, including a bayonet, including a possibles pouch, including a powder measure or powder horn, so on and so 50, 25 rounds a shot, whatever. They had to own that stuff, and they had to bear it to where service was required. So the right of the people to keep and bear arms is not connected to the militia. It predates the militia. You had to own the stuff or you couldn't be in the militia. How could you serve in the militia if you didn't have that stuff already? How could you carry it down to where service was required if you didn't have the right to go outside your home with this weapon in the intent to defend yourself, your family, your community, your state, your nation, whatever?
Well, now we have concealed carry, though, don't we? Now we have concealed carry.
Well,
and there's an interesting case on that, isn't there?
Well, let's talk about concealed carry. Concealed carry is an invention of crooks, because people who were intent on concealing their desires and their intentions would hide their gun underneath their coat or stick their gun in their pocket or in their pants, or, in other words, they did not want honest men to see what they had and what they intended to do with what they had. So the first restrictions on gun carrying, in other words, bearing the arm, everyone has the right to own the arm. We've always had it. We've never not had it, no matter what they say. Now, the courts like to refer to the Statute of Northumberland, which is a 1389 statute where the king tried to take weapons away from certain religious groups. And that's what courts rely on when they say, no, we don't have the right to own a weapon. But they're cherry picking, because later Charles II lost his head over the fact that he tried to take the guns away from people. And in the United States, obviously we had the right to have the gun because we were able to fight those tyrants off. So now we have a situation where we've progressed a couple of hundred years down the road, and it's very commonplace for people to carry their gun tucked in their shirt or in their pants or whatever. In fact, someone made the comment to me, well, it's tactically superior to hide your weapon so that no one knows you have it. Well, maybe that's true, but that is not the right protected by the Constitution. D.C. versus Heller, the Supreme Court declared that open carry is the protected right in order to prevent unmanly assassins or assassinations. Let's see, Young versus Hawaii, Judge O'Scanlan quotes Heller, and he says concealed carry is not a right protected by the Constitution. The NRA ought to know that. They've lost about the last 6 cases they tried to prove that concealed carry was a constitutional right. It's not. Open carry in plain sight for everyone to see what you have and what your intent is. That is the core right of the Second Amendment, and that's proven by the guys on April the 19th. They didn't hide their guns under their coats. They walked down to the green and they faced the British, and the British major said, "Throw down your weapons, you damn rebels." And the captain, John Parker, he said to his men, "Men, do not fire unless fired upon. But if they mean to have a war, in other words, if the government means to disarm us and means to enslave us, if they mean to have a war, let it begin here." How plain is that? That's as plain as the nose on your face, what their intent was, what their intention was, and what their right was. So if we fast forward now to California, we had the right to open carry a loaded weapon.
We did.
And in 1967, the Black Panther Party, and whether you agree with them or not, they had the right to open carry a weapon too, as long as they didn't commit a crime with it. Well, they were using weapons in Oakland, California, and they'd stand on the corner with an old bird shotgun or an old M1 carbine or whatever, and they were monitoring police activity toward their fellow black residents of Oakland. Okay. No one was shot, no one was killed with them, no one was threatened by them. They exercised their Second Amendment rights for whatever reason they had. Then they had a demonstration in Sacramento, and they took their weapons to Sacramento. Once again, lawful legal activity. No one was shot, no one was harmed, no one was threatened unless they felt threatened in their own head. And they walked in the Capitol building and they marched around with these guns. No one got shot, no one fired a gun, but it scared all of the legislators in there. Oh my gosh, black people have guns in California. Oh, but they were scared to death. So the next thing that happens is California passes a law preventing the open carry of a loaded weapon in order to prevent the Black Panther Party from showing up with their weapons at another demonstration and having them loaded. Discrimination. I mean, the Democrats in this state are always whining about discrimination, but they are the party of discrimination.
Well, I can remember in the late 80s and even into the early 90s, some of the stores that I call them, these guys that own convenience stores or repair shops or something like that. One particular gentleman I remember, he and his wife always used to open carry in California. So in Shasta County, basically we had open carry till about 1990.
Yeah.
And but apparently now in the counties, in Shasta County, Siskiyou, etc., open carry creates some sort of threat.
Well, you had the right then, after the Black Panther law, in order to keep black people from gaining access to loaded weapons. Then the state of California went on, and we went on for several decades, and you could open carry an unloaded weapon. So you'd carry your empty pistol on this hip, and you'd carry a couple of magazines on the other hip, or a speed loader, or whatever was appropriate. And then the Democrats, once again, it was, I believe it was Anthony Portantino with the help of Kevin Leon, the candidate for United States Senate. And they thought, well, that's just too scary. And Anthony Portantino made the statement, one should not have to see a weapon while one is drinking one's latte in Starbucks. Because, of course, he's a senator from Pasadena. He doesn't live in the country. He doesn't know how we live. He doesn't care. He certainly doesn't care about inalienable rights. He doesn't even know what they are. He's probably never read the Constitution in his life. So all of his Democratic buddies get together and they outlaw the open carry of a loaded handgun. Well, that wasn't enough because people could carry a rifle unloaded. So the next ban was the open carry of a loaded rifle. So now let's look at the Second Amendment. You have the right to carry a weapon for defense of yourself, your family, your community, your nation. But in California, you can't carry it concealed unless the government says in California is a may issue state. In other words, you may apply for a permit. And if the government feels as though you deserve to exercise that right, they may issue you a permit, provided you jump through hoop A, B, C, D, E, F, G. But any permission that you have to ask for can also be denied. There are counties in California that don't issue concealed carry permits. because no one meets the standard in their opinion. So California has a little known law, PC 26150B2, and that is in counties with less than 200,000 people only, a sheriff may issue a permit to carry exposed, which means open carry, but the word is exposed in the statute, a loaded handgun. Okay, so you may go down to your sheriff's department, and it's funny, we were on a radio show this morning.
Yes,
where the sheriff, where someone asked the sheriff, if I asked you for a 26150 permit, would you give it to me? He says, no, we never give those out. Well, why not? Because my officers might feel uncomfortable if they saw someone carrying a weapon. Okay, so let's see, in California, you may get a concealed carry permit, but only if the government agrees. And in some counties, not all counties, you have the right to ask for permission from the government to carry exposed, a loaded weapon, but they're not going to give it to you. They never give one of those out. Shasta County Sheriff, we never give those out. So do you have a Second Amendment in California? The answer is no. The government may grant certain people that they consider worthy this permission, but they may also deny it. Now, unfortunately for the state of California, Heller versus D.C. says open carry is a protected right. McDonald's versus the City of Chicago, another Supreme Court case, says that through the 14th Amendment, the Second Amendment applies to the states. Cruikshank versus United States says that the Second Amendment is not connected to malicious service, and it does extend to public areas. In other words, you have the right to carry weapons openly in public. And then you have a case called Young versus Hawaii. Mr. Young walks into Hawaii Sheriff's Department or Chief of Police's office, and he says, I want a permit to carry a gun. And the Chief of Police says, well, what kind of permit do you want? And Young says, well, I don't care, I just want to carry a gun. I have the right to carry a gun, I want to carry a gun. And so the county recommends to him that he ask for a concealed carry permit. And so he does. And of course, the county of Hawaii has never, ever issued a concealed carry permit. So even though they invite Young to apply for one, he doesn't get it because no one gets one of those in the county of Hawaii. So then Young goes back in there and he says, well, all right. He says, give me the other kind of permit. Well, what's that? Well, you won't give me the concealed carry permit. Give me an open carry permit. Well, we don't issue those, he's told by the police in Hawaii. We don't issue those unless you are an armed security guard or a police officer. Then we'll issue you one. So now the government says you have no right to carry a weapon in one state in the Ninth Circuit Court of Appeals unless you ask us permission, and we're going to deny it if you're not a security guard, an armed security guard, or a police officer. So Young sues. And thank you, Jesus, he wins. He draws Judge O'Scanlan and another pro-liberty judge, and they rule that concealed carry is not a protected right. No one disagrees with that. And in fact, the Ninth Circuit doesn't even disagree with that because the en banc decision in Peruta versus San Diego very specifically says concealed carry is not the core right of the Second Amendment. It is not the protected right. If you want a concealed carry, you need a permission slip from the government. So now, we ask ourselves, why is that appropriate? Why is that germane to this case? Well, because in that case, the California Solicitor General argued vehemently against concealed carry unless you meet the bar to show good cause and you're a good citizen and you get the government's permission to do it. And he said, concealed carry is not the protected right. According to Heller, open carry is. And since this case does not address open carry, it's not within the court's purview to comment on open carry at all. You simply have to deny the concealed carry wishes of Mr. Peruta, which the court promptly did, en banc. So now we've got this problem, or the court has a problem. Young versus Hawaii, the judge says open carry is a protected right. The state of Hawaii appeals. They want an en banc rehearing. They say open carry is not the protected right. And they advance this really weird legal theory where states can ban open carry or concealed carry because the Second Amendment only contains vague references to carry in public. Well, what is vague about the right of the people to keep and bear arms shall not be infringed, and according to Cruikshank versus United States, that is a right that predates the Constitution. That's an inalienable, natural, God-given right. Now, the state of Hawaii asked for a rehearing. We want a do-over. We want the whole court to tell Mr. Young that he has no Second Amendment right. Well, the state of California sees an opportunity. So they jump in on this. Now they're filing a paper because there's another fake open carry case the NRA is putting forward where the NRA says states can ban one kind of carry or the other, but they've got to allow concealed carry with a government permission slip. It's the weirdest thing. So even though they got handed their hat because the NRA prosecuted the Peruta case and lost in bank, and then the Supreme Court refused to hear it, they're lost. That's over. Concealed carry is not a protected right. There's only one right that is, open carry. So the state of California is hoping to use the Peruta case again to say that states can ban both forms of carry if they want to.
You know, in the conversation this morning with the Shasta County Sheriff, that question was asked, and he even made the point that the position of open carry, most criminals wouldn't open carry because they'd want to conceal it.
Right.
And by the way, the criminals don't follow the rules. However, the next statement was the fact that no, he wouldn't allow open carry for anybody because of the fact that it scares people. Well, really and truly, I'd like you to expound on that because politically we look at all this and we're trying to figure out which sheriff is going to follow our Constitution and which isn't. And one more thing on that. You've made this point before. Article 3, Section 1 of the California Constitution specifically states that the state of California recognizes the United States Constitution as the supreme law of the land. And they also say that the state of California is an inseparable part of the United States.
Right.
So if that's the case, then the Second Amendment should trump everything. We shouldn't have any question about that because even the California Constitution says we have to adhere to the Constitution. So I'd like you to expound on that, especially these positions is it that our sheriffs are politically scared, or is it because they want to control? I mean, who knows what's in the mind of men, but it's almost like they're afraid that they can't control something. If they can't control it, therefore it shouldn't be. That starts to head down the road of totalitarianism.
You know, when you've been deprived of your rights as a people for so long, and this includes the sheriff, he's one of the people, as well as being supposedly an elected official who has sworn an oath to defend the Constitution. It's funny, the insidious nature of deprivation of rights, because you become a class that's mentally enslaved and physically enslaved to a certain thought process where you're kind of like a caged dog. And if you put a dog in a cage long enough, after a while you can open the door and he won't even walk through it because he just is afraid what's out there. And you know, the sheriff made the comment, well, I would be afraid if my officers saw a weapon.
Oh my gosh.
You know, and I see what he's saying, but so now we're in a situation in California where Shasta County issues a lot of concealed carry. People have concealed carry permits.
9,500.
Yeah, 9,500. But 9,500 is not so many when you're talking about 90 or 100,000 people. That's less than 1%.
About 170,000 people.
Yeah, okay, so that's less than 0.5% of the people avail themselves of their Second Amendment right, because without that government permission slip, you're a criminal just for using the Second Amendment, exercising your Second Amendment rights. So less than 0.5% are allowed by government with the government permission slip
And a fee.
and you know, and now training that meets a certain requirement. You know, we're going to tell you how long you need to train, what you need to do to train, whether your training is adequate to us, and you've got to do this and you've got to do this. And if you fail to do these things and fail to pay us our money, then you won't be entitled to exercise your Second Amendment right.
And another fee.
And another fee for the training, right. And you've got to do that again every 2 years, by the way. And so what he's afraid of is that people will be out in public and they'll see a gun. But how many people in public are walking right past MS-13, Crips, Bloods, Del Nortes, Serenos, Aryan Brotherhood, Mexican Mafia, and those guys all have a gun jammed under their shirt? Yeah, well, you can't be scared because you didn't see it. And you know, my sister, and when she was a baby, and we used to play hide and seek, she would stand right in the middle of the yards and she'd cover her eyes. And she just knew if she couldn't see us that we couldn't see her. And we all played along, you know, we would go, "Where's Kathy? Where's Kathy?" And she'd be standing there just giggling. But she knew that we wouldn't find her because she had her eyes covered. And that's what the sheriff's acting like. The guns are already there.
Well,
crooks don't follow the law.
How many states have open carry out of the 50, soon to be 51?
There are something north. It's a number north of 40 states.
Wow.
Allow some form of open carry, either with a government permission slip or without one. But in something north of 40 states, it's possible that you'll see people in the streets with a gun.
Well, so how do those police officers handle that? How do the other states do it, and our state can't do it?
Well, here's the difference: can't and won't.
That's
Our
true,
state
because
can
the county sheriff does have the jurisdiction
Yeah.
to be able to allow
That's right.
carry.
In counties with less than 200,000.
Right.
Well, so how does that make you feel? Now, we say that through McDonald versus Chicago, that the Second Amendment applies to the states through the 14th Amendment's equal protection claim. That's how McDonald versus Chicago prevailed. That was the logic. So we can say we have a Second Amendment here. McDonald v. Chicago tells us we do. But what if you have a Second Amendment that you can't exercise? And here's our problem. There is no constitutional way to force a state to stop enforcing an unconstitutional law unless you sue them.
So we'd have to go to court.
So we have to sue the state of California to force them to follow the law as the Ninth Circuit Court, their own circuit court, has found it to be. Now, the state of Hawaii is asking for an en banc reversal of Young. And they may get it. But here's the problem for the gun grabbers. Here's the problem for the Democratic Party and the Tyranny Party in Sacramento, and that includes Republicans and Democrats, by the way. I believe the sheriff here is a Republican. But he's a tyrannous too, because he cannot stand the thought of you having unfettered access to your constitutional right. He can't stand it. It keeps him awake at night because he might be afraid if a law-abiding citizen exercises an inalienable right. Think about that. I mean,
Wow.
That's crazy. But so we got to sue him. I'm trying to do that. I've asked my sheriff for a 26150 B2 permit 3 times. He's ignored me 3 times. I'm going to write demand letters to several other counties demanding a 26150 B2 permit. I won't get it from them either. And at that point, I have been deprived of a core constitutional right by the state of California, and I'm going to sue them to try to restore open carry of a loaded weapon in California.
I need to ask you this question only because a lot of people are aware of this, and I know you can give me clarification, and everybody else that's watching this clarification. And that is, if you have open carry, and it is your right to have a weapon, it is your right to carry an arm, and if you have open carry and you are arrested for that, could that fall under Title 18 Code Section 242?
Of course.
Okay, so there could be, you could use that as a lawsuit.
Yes.
And it is a felony if the sheriff or if a
Yeah.
police officer would stop you. That would be a felony.
Well, Title 18, 241, 242 is deprivation of rights under color of authority. That is a criminal offense.
Oh,
so,
yes.
so in other words, if a public official or peace officer or any two of them conspire to deprive anyone of a constitutional right, they're guilty of a felony. And then Title 42, Section 1983, 1984 is the civil penalty for doing the same thing. And that applies to state actors, state officials, public officials, peace officers, and so on. And so, yeah, you could. But here's the problem with 241 and Title 42. You got to get arrested to sue for that.
Right. And
now,
once you do, they take your guns
exactly.
and everything else.
And
right.
then you're a felon. Right. You know the first 3 courts are going to find against you because because we live in a tyrannical government and all courts are corrupt because the judge knows who pays them. So here's a way we can do it without anybody getting arrested. We sue them for deprivation of constitutional right. Anytime, anyone who conspires to deprive you of a constitutional right is guilty of a crime, and there's a civil penalty for that crime.
So the conspiracy factor is what we could use?
Well, for example, we have a sheriff who may issue permits, but I'm never going to issue one of those.
Well, okay, so therefore,
If open carry is your constitutional right, and a peace officer stands in front of you and says, I could give you a permit for that, and it's your right to have a gun, but I'm never going to give you a permit for that.
We had somebody say that that was podcasted all over the world.
Yeah.
Good grief.
So there you go. I mean, we have a case, we have the grounds for a suit. We just have to find a lawyer with backbone. We need a lawyer with the backbone to take this case. And not many of them are willing, because they don't want to be ostracized in the courts of California. They don't want to be ostracized in the legal community. I get all of that. It's a pool they have to swim in every day to make a living and put bread on the table for their families. But certainly there is one guy with the courage to take this case out there, and I'll find him. And if I don't find him, I'll write it myself, and I'll act as my own attorney. Not smart, but it might be the only way to do it.
Who was the gentleman who won that case? Was it in New Mexico? The land case that he won. It was a land grab. His daughter.
Danny. Gosh, can't remember his name. No, his name was Danny, and I remember him.
Yeah. I'm trying to think. What was her name? Do you remember? We met her with.
Karen Bud Fallon was the attorney.
Okay.
Yeah, and
okay.
yeah,
Ramona Morrison?
Yes, Ramona Morrison.
Right. So, you know, but Danny wasn't a lawyer. He did it all by himself.
He did it all by himself.
Right.
Yes, he did.
So,
and won.
Yeah, he won. But it was torturous, and it cost them everything. It cost them their home. It cost them their life savings. It cost them everything they'd ever have. And what did they win? They won something the government should have never taken from them to begin with, and they're still fighting over trying to get that back.
Well, you know, and that's the thing the government does, and even when you speak out, you know, people, even in law enforcement, can trump up something on you, no pun intended, but they can take something, trump it up on you, and all of a sudden you become a political pawn and a political enemy, even though you're adhering to the Constitution, and all you're trying to do is to get your elected officials and the people that are appointed to follow the law, follow the Constitution, follow the United States Code.
Well, yeah, and I guess everybody has to ask themselves this fundamental question. Am I going to die a free man or a slave? I mean, that's the open question. Personally, I will not die a slave. I will die a free man. Yeah. And to coin the phrase, that a famous patriot uttered, and he's now dead, by the way, at the hands of the government, the United States government. I don't know how long or short my life will be, but I'm going to die a free man. And he was later murdered by the government in Oregon. And there's a trial going on right now with regard to the 2 FBI agents who shot him and then lied about it afterwards.
That's right.
So you have to ask yourself, what is your freedom worth to you? Do you have anything in your life, any freedom, any cause, is there anything worth shedding your blood over? Is there anything worth sacrificing in your life? Are your children's freedoms important to you? Is the freedom of your nation, your state, your family, is any of that important to you? Are you free to keep the money you earn? Are you free to defend yourself and your family? Do you walk around in fear of the government all the time? Because in California, I think they say that the average guy commits 1.5 felonies a day. They crank out 900 laws a year here. And every one of them is designed to make your life more expensive or more dangerous. And that's what we're fighting here. So I think that the key to that is representation. If we don't get more representation, then we won't survive here. We'll all be broken, we'll all be gone. And if we don't restore liberty, the same thing's going to happen sooner rather than later. So to me, the time to come for 51, and it's time to fight for liberty, period.
I agree. And I think that the main thing, Mark, that we have to look at now is, what are you willing to do? What are people willing to do? When are they willing to stand? And as you said before, what's their line in the sand?
Yeah, I mean, it matters what you stand for. It matters how you stand for things. It matters that there are things in your life that morally are acceptable or unacceptable. And if you find that the government acts contrary to the interests of yourself and your family and your liberty, are you willing to do anything about that? Or are you simply a compliant slave in a failed socialist experiment, and all you have to look forward to is more of the same? Because, it's funny. In 1919 in Russia, it wasn't the Communist Party that took over the country. It was one trade union that somebody convinced that they were right and everybody else was wrong. And they conned them into picking up arms, they conned them into shooting their neighbors and disrupting a political system that lasted over 100 years until it finally collapsed under its own weight. And the law-abiding, liberty-loving citizens did nothing. They died like sheep. On Kristallnacht in Germany in 1936, if every single Jew had answered the door with a butter knife or a steak knife or a bird gun or a baseball bat, I don't know, maybe the Nazis wouldn't have got away with that. We have the right to defend ourselves, our family, our community, and our state and our nation. We have the inalienable right to do that. We did not allow the English government to take that right from us. In fact, we fought. We shed our blood, our treasure, and our sacred honor to stop that. Are we now not willing to do the same thing against our own government? Remember, that was our own government. I am. I will not die a slave in a slave state. I will die a free man. Whether that's tomorrow or 25 years from now is irrelevant to me.
Time has really come.
Time has really come for 51.